Yes, I agree.
Item number 2.
Submitting the field of the petitioner and the proprietorship concern. The petitioner and the proprietorship concern.
Who?
The petitioner and the proprietorship concern.
Oh, proprietorship.
Yes. And it is agreed by the fact that there is a tender notice by the states, whereas they have called for supply of personnel, manpower, supply of.
They have said firm or a company. That is the matter.
Yes, ma'am, that is the matter. The Lordship will see.
You remember that the clause, firm and a company, was not the proprietorship concern. Piece 20 is the eligibility criteria.
Page 20, ma'am, eligibility criteria, section 2.2, global one, ma'am.
Partnership under the Indian Partnership Act, society registration, trust,
Yes, ma'am.
but not the proprietorship concern.
Not a proprietorship. And then the second clause, ma'am, that is at Roman 5. They should have a minimum, should have minimum.
That should be there. That should be there, sir. Because this is what for this tender is called.
Tender is for supply of manpower.
Yes, true. But in a hospital, healthcare, yes.
Well, so far as I would only respect to submit that
Clinical.
supply of manpower.
We must have experience of this paramedics, nursing, or a clinical services in the health.
So
That is the
cyclone and all.
That's
So facility supply,
Yes,
that is so
that is-
but it requires expertise on constructing a girl hostel or what.
We respect to submit. This is supply of manpower.
No, sir. Manpower in the health sector. And then they say that they are dealing with the human life. Trying to visualize. In medical suppliers, we have made a distinction that if they are dealing with the human life, at least some expertise must be there. Suppose if they see that somebody is very getting serious, he should know and immediately call the doctors or the attending, whoever is there to save the life. We cannot go that unskilled person, only man supply, that is not there in the health sector.
But therefore, I'm not compromising on the quality of the requirement of the personnel. So you could see at page 34. At page 34, what are the
Your
kind
first point appears to me, us have some substance so far as the exclusion of the proprietorship concern is concerned when they are including a partnership firm.
grateful man?
I can understand.
Yes, ma'am.
Discrimination cannot be done in that.
Moment, the logic can at least have a class to page 34, ma'am, of violation was. But I'm not compromising on the quality of the personnel or the requirement of.
No, sir. If they have put up parameters that 3 years experience must be there, it has to be.
So, under similar circumstances, but it's slightly different, Lordship, actually, very recently, Honorable Supreme Court has struck down such a clause where the state required that the personnel should be, there should be experience of having supplied to the particular state. Lordship, can we have a branch to this judgment?
No, please, because we have to consider that in what sector that was required. And what is the nature of the job they have to.
Supply of sports kits, fellow.
That is what I'm saying. There is no problem in the supply of the sports kits. But so far as the health sector is concerned, no, we cannot compromise on the quality. We will not, under no circumstances. That's our view in Utkal. We have taken a firm view. Will not declare.
Subsequently in another matter. Subsequently in another matter, then
Health sector, no, there should not be any.
I quite agree, my lord. I bow down before your lordship, but only think that so far as the quality of the personnel is required, but I'm not compromising.
They must have some kind of experience in that. Can't you visualize? Sometimes it so happens that they are there in the hospital. If somebody, maybe a menial staff who is there, suddenly he found that the patient is getting some kind of a trouble. Unless he has an experience that what he has, he will immediately call the doctors to attend him so that you can save the life in a time-bound manner. And this person who does not know,
So far as supply of manpower is concerned, but I'm not, no, but I'm only supposed to supply the manpower.
manpower for what?
Manpower for the requirement of the clinical
That is
establishment.
what I'm saying, that if they have put a certain experience conditions, I think that there is a rationale behind it.
But
In a health
that's
sector.
what your lordship, in fact, the central government had called for a tender to supply of engineers, diploma engineers. I have supplied manpower.
No, engineer, can't you visualize the engineer is something different than a health sector? We have made a distinction in Utkal suppliers. We made that in other organizations there may not be, but in a health sector, can't you visualize you are dealing with a human life? Are you not? Can you show any complacency so far as the health sector is concerned? Cannot be.
Cannot be done.
You have to.
Efficiency cannot be, the requirement cannot be.
No, sir. Experience in a nursing or a paramedics, that must be there, at least from a clinical visual. Somebody can say that he's not well, he needs immediate attention. This much experience he must have.
I mean, that is the requirement of the personnel. Suppose if they need a nursing man or
No,
they need a laboratory.
no,
technician,
any
I'm not
person-
comparing.
No, sir.
But so far as I'm supposed to only supply this.
Supply with the manpower who has, and there must be, your experience must be there also. That you are supplying, having a 3 years experience in this.
Okay, in fact, I will do something.
But you are supplying somewhere that does not mean no.
In fact, I will.
What is the nature of the manpower? Oh, this is the paramedic nursing and other sir, managerial service. Then experience is necessary.
Government.
Experience of the service. Manpower.
No, sir. For what services? Please consider manpower for what services? It's a paramedic services. You must have experience.
But
Hmm.
so far as the builder is concerned, he did not have any experience. But the manpower may not get, the operation they didn't have the experience.
No, sir. You may supply manpower. That is a very common thing. But these are the expertise, or I would say the special sectors where we can't compromise on that. No, sir. We don't think so. We don't think so.
So far as
Even if we consider this, we will say that this can't be the criteria. If he can show that experience is there, he admits that there is no experience. So there is no point in, but you have to amend this clause.
Consortium is also excluded.
What are you talking about? Are you aware of the concept of consortium? What is the meaning of the word consortium? I am asking, sir, you are creating a classification within a class. What is the intelligible difference here when you create a class? Is it not offending Article 14? You are including a partnership firm where more than one person are working, and where only single person is working as a proprietorship concern. You are eliminating him.
That is what is,
Very interesting.
that is what is flagging. The individual may not have the experience, but he can provide such experience with personnel.
But that is
Similarly, you have not identified the company.
No, sir.
Only company. You have said any company, any partnership. Any partnership.
So
So partnership firm.
provided by.
Madam, what is the distinction between a proprietorship concern and a partnership firm? Tell me.
Proprietorship unless it's a single individual handling the partnership is more than a,
More than one?
yes,
So there may be a 2%.
yes.
So one person who is more experienced in supplying and 2 persons having no experience in supplying. What is the distinction? Why classification is done? There must be a rationale. You have to show the intelligible difference here. You know the line of judgments of the Supreme Court. Classification within the class is permissible provided there is some nexus to the object to achieve.
And it's this tender as in.
It cannot be, but we accept your first contention.
Here the tender authority which quoted the tender, they cannot modify because this is a district authority and they are the tender is floated as per the direction of.
We do not know, madam, there are two aspects of the matter. I am telling you the difficulties. If we find any of the clauses offending the fundamental rights or the constitutional provision, should we simply sit or shut our eyes, become a stubborn and a mute spectator that the authority have done? How can you make a distinction?
That is done as per the direction of the state authority.
So state, then there cannot be any litigation. Then according to you, if the state has not committed any violation of the constitutional right, I believe I will be the happiest person. There will not be any litigation against the state. Very happy. No problem, because we are grappling with, I think the majority numbers of the cases are against the state because they are not following the statutory provision or the constitutional provision. That is what the petitioners alleges. And sometimes it appears to be so. So what you are talking is that once this district administration has taken a decision, it is untouchable. It cannot be touched. It cannot be even seen.
Submitting these files, the district authority is bereft of any power to amend this provision because
We are not talking you to amend, sir. Madam, we are not saying that to amend. We will definitely declare this provision to be unconstitutional. Article 14 you have violated, Article 19 1G you have violated. Both.
Rather, individual has to be read into this clause.
It should be included in the clause.
May I be permitted to bring forth in the form of a counter as to the classification, the connection, the classification that they.
Show us one ground.
Why they-
Then we'll have to stay. Do you want that? We do not want the stay to come. So tell us. Tell us. Tell us what is a nexus? What is the object you sought to achieve by eliminating the proprietorship concern? Tell me, I am ready. What object you will achieve by eliminating proprietorship concern when you are including a partnership firm? Show us, if you can satisfy us, yes, this is the reason, laudable reason, reasonable reason, no problem. We will say that is correct.
That's fairly granted a day's time.
What do you mean? The government advocate is here.
Sir, I'll also try.
Government advocate is here. Sir, what troubles is the clause. The authorities have included company, consortium, partnership firm, trust, society to participate, but eliminated proprietorship concern. Why? If you included everybody, why? What is the reason to eliminate proprietorship concern? That is the experience, sir. We are not tinkling or tinkering with that. First clause.
So as to be seen the nature.
A proprietorship concern may have an experience also.
Yes.
Maybe. We are not concerned with 5. We are not with him. We are concerned with 1. Where are the judgment of the classification within the class? There are series of judgments which has come.
There's also judgment of the division bench of the Jharkhand High Court, wherein this criteria, the eligibility criteria where a sole proprietorship firm was excluded. And in that case, the High Court refused to interfere in that matter, and it's on the ground that the state has a discretion to frame its eligibility.
Eligibility? No.
That's
We fully disagree with that. We fully disagree with that. It is offending Article 14 and 19(1)(g).
That's
Today morning, I received the brief. Today morning only I received the brief as well as the Hinaman. So for my instruction is concerned.
So have you got an instruction?
No, only one instruction that regarding the blacklisted ban, which we sought for from the HAL, this is the letter.
What?
The person is blacklisted, Lord. He is debarred from participating in tender. They sought for a clarification, sought a clarification from the authorities whether he is blacklisted has been also
Withdrawn
or not.
revoked.
How can they do that? That is my case, Lord. Must you kindly come to
No, I do not know this.
This is the HAL.
Anuja Kanto.
The notice
he has been selected, Lord.
he has been selected. He is the petition.
You are the minister. No, he's a LK associate.
Number 4, who has been selected by the municipality, Lord. It's a sanitation tender, Lord.
So for the detail is.
You are blacklisted.
No, the person who has been selected is blacklisted.
He says that no, he's not.
No, that I'm coming to, Lord.
Please,
So,
sure.
Lordship, a sanitation tender was floated, Lord. And Lordship, important is, page 26. The general terms and conditions, Lord, 14, Lord.
No, blacklisted. If it is he's blacklisted, he is not entitled to participate. No doubt. Just show us the document that he is blacklisted. That's
Exactly,
all.
Lord. Then your Lordship may kindly come to page 40. Lordship may come to page 42 first, Lord.
Yes, sir.
During technical evaluation.
No, that is what 7 have applied.
No, they have stated that he is
Blacklisted.
Yes.
Who is number 4?
It's a Kantorio Lordship, 5th line, Sri.
No, he has not said blacklisted.
And he has submitted CBI court order by PR number after brief. This is not CBI court order means he was blacklisted there.
Paragraph.
No, that is a paragraph, actually.
Then Lord's may come to path 45, page 45 and it's 10, Lord.
Just. Anyhow, where is the CBI, that court order?
No, he said that nothing is been.
Where is the document? Where is your document that he is blacklisted?
No, this is not our documents. Not our case is that he has been blacklisted.
Where is the document that he is blacklisted?
Look, from there, own showing, it will also again.
Where is that? Where is that? I just wanted to know.
Then come to page 45, Lord.
45.
Yes.
Show us.
Municipal authority writes to Sunabra.
No, this is a proceeding for presentation. What is this?
They stated that he is blacklisted. They said that he is
What it
blacklisted.
says in that page
42.
42.
Page 45.
42.
42. Just where it is similarly
Blacklisted objection arises against Kanto.
Yes.
And he has submitted a CBI court order. After brief discussion about their submitted document, the tender committee allowed them for opening the financial. That means overruled it. Then it shows that where is the blacklisting?
Lordship, kindly come to page 45.
45 is the,
Municipality says he is blacklisted.
yes.
With reference to the subject cited above, it is to inform you that you have submitted tenders of sanitation package number 1 and 2. However, complaints have been received from some bidders alleging that you have been blacklisted by all authority. Due to this office has not finalized till then.
No, that is your objection is there alleging that he is blacklisted. No, this is not a sacrosanct.
No, because I'm saying that there is some.
Where is a document that he is blacklisted? No, by HAL. Okay, have you obtained any Right to Information Act under the Right to Information that the HAL has authorities have blacklisted? Show us one document, no problem.
No.
Whereas he says that he is not blacklisted.
Now the municipal answers no more blacklisting there. Anyway, I submitted notes because he submitted documents from the CBI court that he has not been blacklisted. They allow him. That is one ground. Second ground is your lordship may look at notes. Clause 14, paragraph clause 14 minutes of that general
Page.
What minutes? There are two grounds I've said.
Page.
Page 26 minutes.
26. Yes.
Paragraph 14. Clause number 14 minutes.
Yes.
The bidder should quote rates both in figures and words. Wherever there is a difference between the rate quoted, figures and what the rate quoted in words shall be taken as well. Lowest bidder will award the contract.
So,
Now, Mr. Lordship may kindly come to page 43, Mr. The price,
yes.
I'm at serial number 2. LK Associates Coram. My price 14.
But you are already blacklisted, sir.
No, I am not blacklisted now.
He's not blacklisted.
I am not blacklisted.
Okay. So,
My rate is 14 lakh 2,226. The person who has been at serial number 6, Dhananjay Kanta, his price is 15 lakhs 27,000. He has been qualified.
where is your figure means in words?
That I have submitted to that through net. It's through online. There I have given. It is there. They are documenting. They are proceeding. They said that I don't know what is the reason for disqualifying me. Because I have quoted 14 lakhs. They said I am disqualified.
What is the reason for disqualifying if you?
I sought an information and filed an affidavit. They said that because of clause number 32, man,
32.
page 27.
Yes.
The evaluation will be based on the service charges of the manpower component quoted by the bidder, not less than 3.85% of the estimated cost. So he has put his bidder less than 3.85. Because today morning I received the brief. So
But his price
that is
quotables are
instruction,
more.
only oral instruction. That is
No, in
instruction.
the proceeding, they have written that it is
Yes.
15 lakh and all.
Has qualified.
Yes.
In the financial bid, that is the oral instruction today morning only I received. Unless and until I produce the document, man.
So I fail to understand that he has quoted the lowest price
Lowest
and
price.
you have given it to the highest price.
Lowest price.
And you are given to a highest price.
15 lakh 27.
That is the highest price. Highest price. Yes. Why you have eliminated Grovist?
Yes, that is the instruction that he has submitted his bid in less than that clause number 30.
So I do not find then where is a based on a service charges on the manpower. So he must have quoted the service charges.
Service charge.
Then why would you granted the other
I
person
have a glance there.
who stated to be black, supposed to be?
You not kindly see they have annexed a document of office memorandum of government of Odisha as well as government of India, page 39 and 40, which say that the minimum service charges shall be 3.85%. They have quoted less than 3.85%.
No, we have quoted 3.85 loss. That did Lordship kindly it will clarify. If Lordship kindly come to page 35. 35, they say Lordship kindly estimated cost 14 lakh 70,000. On that, he said 3.85. He brings it to 50 lakhs and they grant him.
That is statutory. No one can reduce that percentage.
Yes, sir.
Statutory
In
rate.
instruction, they have quoted rate.
Whatever statutory rate is fixed under the fiscal statute. Less than that, nobody can quote it.
Mine
It is obvious.
These are total estimated costs,
Is 14 lakh 70,000.
70,000, and they have quoted 14.2. So can it be more, less than 3.8% of the estimated cost?
No, what he says is he has quoted less
1%.
with respect to taxation. Taxation, service tax, or what? They have
No.
3.8
What he says,
service tax.
he says,
3.8 service tax.
On this
Service tax he has quoted less. That's why he rejected. If he can, if he can,
I could have also done that.
other instructions.
sir, from his own pocket, he doesn't want to shift the burden of indirect taxes onto you. He wants to pay from his own pocket. One man can shift the burden of indirect taxes or not.
Have you issued a notice on that gentleman?
No. Because you also wanted me to serve prior notice on the municipality.
Correct.
The short notice
Yes,
now
yes.
it has to go.
14. But your price is less than 3.
Mine, Rosame, can look at, I've given the document to them.
No.
Rosame, look at this.
Mathematical calculation.
Yeah. Let's say serial number 1, 2, 3, 4, 5 are statutory. You know, labor cost.
No, it is, they called it a estimated cost. So estimated cost is 14,70,000.
That they've done it.
That is what is the not less than estimated cost. It does not talk about
But they
anything
don't
else.
say that it cannot be less than. Because Rosame, kindly look at my document. If I have quoted less than 3.85, I will withdraw my case. So Rosame, look at 1, 2, 3, 4 statutory. Not labor cost, it has to be 9,42,000. Then not supervisor, it cannot be less than this. So it comes to 9,72,000. EPF in respect of component 13% on 68%, so it's 1,26,000. ESI, this is mandatory. Then we have overhead charges at the 5% of labor component, interest 48,000. This is also mandatory. Service charges 3.85 labor component as per government notification dated 3/37. I quoted that. Then was other sides I have given less.
Oh, service charges. Oh, this is a service charges.
Not service tax.
Oh, service charges is something different.
Yes,
Okay.
it's statutory.
It is statutory. Government notification is approximate.
Yes, if I hire a vehicle at a lesser
No,
cost.
I was under the impression that service charges means that manpower which you are supplying For that, you are giving a service. For that, you are quoting this 14 lakhs to 2,000 is a service charges. And then I was calculating from the estimated cost that it comes below 3.85.
It's not that. My cost is vehicles, I quote lesser, high service, I quote lesser.
How you gain? Where is your profit?
Because profit is, they have shown the hiring charges of vehicles, transportation, the higher cost. I've given my possible next, because that is transportation cost of garbage.
Sir, I'm just trying to figure out your profit.
Profit is because I was talking to them, he says maximum 50,000 per month. At 14 lakhs, it is 50,000 per month, which is agreed to. And now they make
But
it.
this figure does not show that you are having any profit.
Oh, profit not say because I will definitely have profit because I've got my own vehicle.
Sir, how can you do it? If this is correct, service charges is something else statutory, then
Let me obtain the instruction.
then we'll have to stay. They have to stay on both so far as the
If in the manual work order has been issued, that
more than a stay, they have to stay. But this is absolutely
this is.
arbitrary on the face of it. Absolutely arbitrary. The petitioner has
that is issued.
Just see that when the old file comes, at least the dust is not there. That created a problem to me. So it is-
But I was dwelling on
One application, more than one application.
no, that for the gazette notification, the by order of government. I was dwelling on the point.
Yes, so have you seen that,
That the correctional that was issued in that secretary sign not mentioning by order of the governor.
correct.
So that is to be corrected only. That should have an actual requirement of rule 11 of business regulatory 162
Sure.
Constitution in India. All orders to be expressed in the name of made in name of the governor.
Correct.
That
That
is
is
what
right,
it
because
took
that was put into the official gazette in the name of the governor.
Yes, sir.
But once you substitute,
That has not been mentioned.
done, then how?
That we have to implement.
No, in the official.
Further order we have to make.
Because he has substituted, it means amended or done anything there.
Yes, sir.
Had it been a typographical error that in case of is, it is are, I can understand to that, there is no problem. But he has in overall substituted that clause. Can you do
Further,
it?
will make my lord by mentioning the by order of governor. In the correction that is,
For addendum, he has not.
that is not done, no by order of governor.
So how can it go?
Will further will make it.
That you do it. That you do it. That you do it. There is no difficulty. You can do it.
So on the face of it, this corrigendum doesn't.
Yes, sir.
Has no application.
Yes, ma'am. That's the end. Who work to be said?
Judgments?
That was gadget.
The Sukla Munda is there, but then that's the case of the rules. This is the case of order 166. Sukla Munda paragraph 11 to 16.
Rule 11 government goods and business also says so.
11 and 12 rules. Please.
11 and 12.
But this in case of say rules, madam. Ours in the case of a order.
Yes. All government order. But there is a judgment of the Supreme Court. It says that when it is by a governor, then any amendment or anything is to be done by an order of the governor.
That's rules of business rule. That's it.
66. 66 constitution also says Article 1.
That's it. There are judgments on the rules of business.
Yes, but I'm sorry, but I have not.
So you come because it has a larger impact for future.
Yes. I should give it to it. In fact, the lack of research is there on our office.
When is the last date?
Last date is, it starts from yesterday, 5th to 18th, no?
11.
11. Yes.
11.
Yes. Last date.
So what we are doing is we are passing an interim order permitting him to make an application as per the original. Not insist upon, we are staying the corrigendum for the time being and then give me all those judgments, we will dispose of the proceedings.
I'm surprised.
The challenge is restricted to the
Item number 8.
Mr. Roth, you did not point out this issue.
It's various issue.
You did not.
Another issue.
Hmm.
Yesterday, it's not clear, actually.
Yes, you did not.
I'm grateful.
No. And now.
Regarding the unblocking aspect, my lord, I talked to Chief Engineer already suggested to the technical committee for taking decision 5-5. I have asked them to unblock. It will take some time.
How much time?
1 week time it gives.
Next week. You require the ultimate decision. We will decide the cost, don't worry.
On fresh admission, which is otherwise it will not.
Oh, yes, on fresh admission.
This is a case.
This is a case which.
No, yes, call.
Weekly list, item number 1.
So this matter has already been had, supposed to be stated for orders in that. And
To be mentioned.
that regarding blacklisting, that whether and constant achievement milestone and not achieving the quality. But I'm just,
I have also filed my note of submission along with justice.
I'm just reading for clarity, my lord. Register. But I'm just. Since for convenience, without going to brief, let the fact easily only this short date and also everything.
Brother, can you think of it? Blacklisting.
What is it?
This my lord, during pendency of the case, there is a judgment come before your lordship that Rinavala said. The standard OPW provide for inquiry before you blacklisting, which is not done. So in consolidated, I filed the date chart and so on. All judgments has been already filed except Rinavala said. Everything has been. So that's awkward because
You have also filed the notes of. Yes. The respective parties filed their notes of argument. Notes of arguments. And the my instinct is always on the right side. I'm not an.
Item number 2.
Excuse me, Lordship has already heard the matter earlier. Here is the case where Lordship filed without so called notice. The order of department was passed by the annexure 4. So this case what is happening. And in that provision which governs the claim, there is no scope for this scope. So,
But Karunakaran's judgment will have to give us. It's a civil death. It's a large consequences.
AK Developers Limited.
That is what is there. I am talking about the parent judgment where there is no provision for a show cause. It is said that you have.
There is a provision. There is a provision, but probably my lord.
But that is not
accounting
lordship.
Annexure 6, para 30. There is a provision. But AK Developers says that issuance of show cause notice, that is no more in the review of the series of distance matter. In the latest judgment that AK Developers, there this Honorable Apex Court, while considering that show cause notice itself is a final notice, therefore the authority should consider whether to pass a show cause notice. And in that case, what happened in my lord, since the order
That was in case of a debarment.
yes, blacklisting and debarment, same thing.
I know the same thing.
My lord, in case of the debarment, and in that case, the Supreme Court has further held that since already the more than half of the period is over, what happened in this case also, therefore, instead of directing to issue show cause notice, was the that order of blacklisting.
Where is that judgment show us?
Yes, sir. I'm sorry, my lord, that office copy was
It's not a, what is this?
by mistake. I have
So no, Gorkha, we have considered, which
Not
AK developers, where is that?
last but one judgment.
UNC we are aware.
That is AKG Construction and Developers. What's the state of Jharkhand and others?
Oh, it has not been reported. April.
It is live law reported.
No, it is not a live law reported anyhow.
In para 21.
Just, I have a bad habit of reading the whole judgment.
Yes.
Just bear with me for
Yes, sir.
few minutes.
Hey.
Oh, not E 140. 140. Yes.
Admits that he has filed a false affidavit in paragraph 4.
Maybe.
My lord, the affidavit also.
I just seen that this latest judgment of the Supreme Court on this AKG constructions and developers. It is a latest judgment of the Supreme Court on April 2026, April 2,
I'm not
2nd April.
I've not gone through it.
And I'm giving you.
But in the case,
There also, what has happened? That's a more, I would say, better case than this. That was a more better case than this. A show cause notice was issued by the authority that you have used the spurious materials, inferior quality of materials, everything was done. Why your termination be not done? The fact-finding authority found guilty there that he has misused, he has used the spurious materials, inferior quality materials, all these things, terminated the contract. Simultaneously, it blacklisted the contractor. The court says that I'm not going to interfere with the order of termination. Clearly justified. All the allegations which were made against the contractor appears to have been proved. See, better case than this. The court says, yes, it has been proved beyond any doubt. But the court says, no. Termination on the basis of the offense cannot be used as a tool for blacklisting because both are distinct and separate. You must give a specific notice of show cause that why you should not be blacklisted on that. The court was grappling with the situation. It says that we are upholding the order of termination of the contract on a proven fact where the guilt is there. Everything has been found against him. Here also, false affidavit found against him. He has done it. There also, it was found that he is guilty. Yet the court says you can't. And then the court says that you'll have to issue a show cause notice for blacklisting, specific, not for termination. Argument was very interestingly advanced by the authorities. It says that there is no show cause provision for termination of a contract. So once the show cause notice is given, it will be deemed that it is for blacklisting. I'm telling so. This was discarded. It was discarded because you did not mention that you are going to blacklist. That is what the judgment says. You have to mention that you are going for a blacklisting.
But in the but in notice dated
142. What you are saying, you can't take advantage of 1 year, 5 months, and no further show cause notice to be issued. The Supreme Court has really applied 142 principle.
Paragraph 21.
Please read. I have read it. It's a Article 142 exercise of power.
And humility, another aspect, only factual aspect.
Yes. On 25/10/2025 letter, the last paragraph is specified in this way. Therefore, as part of 2.21c and 2.22 of the special condition of the erection of minor catering units, SMU such and such station, such and such, you are hereby debarred from the.
That is a decision you have taken. Where is a show cause notice that you have done these things and why not you should be debarred or blacklisted in terms of those clause? Then you must give an opportunity to file a reply, audi altrum partem, and then pass the order.
Immediately, not that he is debarred from any contracts. He is.
Whatever be the reason, debarment, Eurasian judgment, global judgment, security, I think Gorkha security judgment.
Techno prints.
Techno, every judgments are uniform. It is a civil death. Once it is a civil death, then how can you?
Honda has no.
Huh?
Honda.
Infrastructure from our High Court has not been referred to. But sir, how many days you are debarred?
25/10/2000.
Since when?
1 year, 7 months already passed.
Already passed.
That is the reason why we will also kind notice. And with all
that is Article 142.
Now what they did, that the blacklisted order is set aside with immediate effect, not perspective.
Sir, I understand with immediate effect, with the observation that They should be directed to issue a fresh show cause notice.
Don't need to.
But the court says that it will be a futile exercise because you have already suffered without any interim order in that AKG construction. Says more than 1 year, 6 months have already passed and you remained a debarred. So I think that is quite justified. So no further show cause to be issued. That is the period which will be considered to be a debarred.
Ending period 24/10/2027. Is debarred till 24/10/2027.
Already 1 year, 7 months. Another aspect of so far,
We can.
so
There is
far, the
no-
factual aspect is concerned by.
We will not enter into the factual aspect.
That is nothing.
Why we will? We are on a pure question of law. Why will enter?
Only thing, my lord, is that already 1 year, 7 months passed. I know that admittedly no surplus notice has been issued. Already 1 year.
Just imagine what the Supreme Court says. Paragraph 24. Very interesting. As a consequence of our decision to set aside the blacklisting order, we would have required the department to issue fresh show cause notice, indicative of the reasons as to why a blacklisting order is felt necessary, and to thereby call upon the contractor to show cause. However, in view of the fact that the order of termination cum blacklisting was passed on 23/8/2024, and since then almost more than 1.5 years has been passed without there being a stay of the said order in the meantime, we are of the opinion that the release to be granted can be suitably molded by directing that the order of blacklisting will cease to operate with immediate effect. This order will benefit the appellant more than the department because directing issuance of fresh show cause notice will only lead to future litigation. So no further show cause was given. But this is Article 142.
I will not say anything further, my lord. But this is a case already 1 year, 7 months have already passed out of 3 years. She is a lady to should have radio. But I am not on the question of that. And it is a case.
You should
where-
compliment that she's doing a business. Why you are naming that?
No, I am not on that.
So that's
Only thing is, my lord, she has not taken any unfair advantage. No doubt, it is a mistake, bona fide mistake. In the second time also, she participated in the very same auction. Thereafter, she came to know that earlier he has already been blacklisted for giving false evidence. And that affidavit, corrected affidavit, here.
Immediate effect, at least immediate effect means from today itself. So whatever has happened has happened. You have already discarded her, rejected her bid, any other, but
they have
henceforth,
they have already forfeited END twice because he participated.
He has participated. Thereafter also on our demand he has participated.
They should not have allowed it the second time because I was not aware.
E-portal, we cannot understand that. Nobody, this is a secondary issue that yes,
this is what is there. Is a very good. Where is the clause? Is there any
This
clause?
is 2.221 and that is annexure 4. Page 48.
Annexure?
Page 21 in the counter affidavit. 2.22.
2.22. Page.
Page running internal running page 49 internal 20.
Forty-nine. But in counter, you are referring to
21. Running page
counter
21. Internal page 21.
21.
Counter.
Yes. No, 21 is.
.22.
That is at page 23.
Yes. It is also in the annexure 4 also.
No, 2.22 is one-time non-refundable registration shall be paid online.
My lord, let's make consider see the 2.21C and 2.22.
You know what you are referring, actually, I have not again.
This reference let's me see the legible copy is page 17 annexure 4
No.
of the writ petition.
There is no 2.1.c or something. That's why I'm looking at another document. This is a policy.
In our counter, it is page
Counter is
21.
page what? Oh, yes, I got it. Page 20, event of default. You are referring event of default,
Referring
2.21.
to event of record. Yes, correct. Then see, if the railway finds that the bidder has obtained that. Then 2.22 is penalty.
Yes.
There is no provision for a notice.
No. Then no provision for notice, that's why the penalty provision is 2.22.
Yes. Definitely, annexure 6. Paragraph. They are silent on the counter. That's what.
What?
That the procedure provided for the banning of farms.
Page?
Is
That's a freight market circular.
yes.
It is not applicable to this because it is for annual turnover, not for this case. This circular is completely different. We have
They are
that.
silent on that.
No,
Page 24. Page 24 of the restriction.
No, I understand. This is a freight marketing circular number 11. You are referring. Come to page 23.
NFR. Then we select turn to.
Please come to page 23. Handwritten, top, right hand side.
Competent authority have granted approval introducing.
Not a freight marketing circular. Is it?
But page 21, annexure 6, it relates to e-auction. Page 21.
So it is again a freight marketing circular number 11. I am talking about it.
And page 24 relates to how to proceed. And the 30.4 says any bidder or contractor shall not be debarred unless of bidder or contractor has been given a reasonable opportunity.
No, actually, be.
Silent. So far, annexure 6 is concerned.
It is your annexure, sir. It is your annexure 6 and annexure 7.
Annexure 7 is policy questions. Maybe you can
That is your document which my lord is asking that is freight marketing circular you are referring to. You are saying no.
or it is freight marketing circular.
That is what
Catering policy. Annexure 7 is the catering policy, and annexure 6 relates to the special conditions of contract for contract various categories awarded, and then it refers to e-auction also. And your cumulative minor has already observed that even if there is no provision, you have to do.
Sir, whenever any question is put or any query is put by the bench, at least we expect that you will come with the answer.
I'm sorry.
you are referring a document, you are reading something. I just asked you whether this, what is the categorization of this document? Are you referring this document? You're saying no, 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 no. Then I am getting confused that what you are referring.
I'm sorry.
Argue with the open mind, not with the closed mind. I know you are more concerned with the interest of your client, no doubt about it. You should be, but with the open mind.
Yes, sir. I'm sorry.
Yes, this has also an application automatic by virtue of this Ministry of Railways letter at page 21.
Circular is meant for the by the NFR and the non-revenue NFR contracts. And this banning farm, banning few farms in the 30 clause 30, next page 24, 3.30.30.
Is a contractor, is a contractor.
The temporary suspension of the contractor. May I read my lord?
No, no, I understood.
Yes.
What you are,
It is meant for only the annual turnover. It is annual turnover, financial eligibility. It is a completely different issue. Here is the issue with respect to participating in tender by giving a false document for getting a catering. It is not applicable to this. Only that's why we are referring the to 21.2 penal provision, wherein it was specified that what is the punishment, that A, B, C, D is there. This 2.21 events of documents, what Lordship refer to, paragraph C. Then 2.22 penalties. That is actually the Lordship may see in 2.22B. To annul the license, the license and for to terminate the license. It changes time to time. It might be 3 years, 3 months or 6 months or 1 year like this. But it is respect to
Silent counter. Only they say, oh, annexure 5 is not applicable. Yes. They are not saying that annexure 6 is not applicable. Admittedly, counter that part is concerned.
Yes. And it is short. That should be no problem. देखो, you are giving only one page. No. Thank you.
Before I start my submission, this voluminous brief we have filed in volumes, 3 volumes. Those 3 volumes are kept in office. They have not reached my last level. So, I will do that with all
Just a minute.
not till it reaches me, let me start.
Make it so.
Why all the big matters are posted at the top? That's the whole thing, and whole day is being consumed.
I hope Mr. Mahanti.
Since we are taking up all the matter and disposing of then and there.
Yes. No,
I think everybody is more interested there.
I have not inconvenienced.
Because today is there, that is
Mr. Mahanti consistently mentioned it.
paper books not necessary at all. Only to linger to matter, paper books are not necessary.
Very clear.
Very small points are there, your lordship kindly see the order dated 1712.
Before knowing what the petitioner would say.
No. I am not standing on his way. But what is said, that is why I am submitting that lordship will start from the order.
I have not filed it because it is necessary or not necessary. It is filed to avoid this carrying this voluminous brief. Still, we are starting our submission on the rest of the submission. Not to linger my Mr. Mahanti.
It is very voluminous because the whole tender document is fine.
Obviously, it has to be filed, otherwise you will complain suppression of time. But before you are
Total 1077 pages.
the entire tender document is a very big document.
So the only point is that the successful bidder has quoted 18.76 below, whereas you have quoted 14.99% below. So I think
Your Lordship kindly see para 6 and 7.
more the voluminous document, less the legal point it
So
contains.
1 point, it's a very short point. But it is very short. Only the whole document is filed in order to avoid.
Just show us these two quotations, whether your justification
I'll add.
that he is 18.76% below the estimated cost.
I'll quickly tell your Lordship, take your Lordship to the points involved. Kindly see order dated 17/12/25.
17?
17/12/25. Your Lordship, already have been pleased to formulate the point. Kindly see order dated 17/12/25. Order number 1. Rather, let me place it. Para 3 onward. The solitary point involved. Your Lordship's order. The solitary point involved in the incident repetition is whether clause 36 of appendix of Odisha Public Works Department OPWD Code Volume 2 is applicable to a lump sum turnkey basis in the event price quoted by L1 is below 15% of the tender price. Therefore, according to the petitioner in relation to the subject tender, he has quoted 14.99 less than the tender price, whereas L1 quoted 18.76 less than the tender price. According to the petitioner, his bid is liable to be cancelled invoking clause 36 as indicated herein above, whereas authorities have proceeded to award the contract. Mr. Tripathi and Additional Government Advocate and instruction submit that since the tender is invited on a lump sum turnkey basis, clause 36 of appendix 9 of OPWD Code Volume 2 is not applicable. According to him, the price is required to be quoted in rupee, and admittedly the L1 has quoted less price than price quoted by the petitioner, and therefore there is no illegality and or infirmity in the action of the authorities in awarding the contract of the said successful bidder. Para 6. Clause 36 of appendix 9 of OPWD Code Volume 2 doesn't make any distinction between lump sum contract / turnkey contract and the other contracts. 7. The question therefore is whether clause 36 has its applicability in a specified category of tender or has an omnibus application in relation to tender quoted by the government. Our attention is drawn to letter dated 10/7/25 issued by Works Department, Government of Odisha in relation to one of the tenders which is quoted on turnkey basis. A conscious decision was taken that since L1 bidder has quoted less than 15% of the estimated cost put to tender, it offends clause 36 of Appendix 9 of OPWD Code Volume 2. Therefore, the entire tender was cancelled. The aforesaid letter and the stand taken in the instant repetition appears to us that a discriminatory treatment having perpetrated upon the intending tender, the authorities cannot apply a provision in a tailored manner. Uniformity and certainty of the applicability of provision is a hallmark of Article 14 of the Constitution of India, and therefore we find prima facie case having been made out as an interim order, we directly lordship pass the interim order. Now, but I will have to show now the counter event everything has been filed.
Volume 2.
But I am filing the compilation of all the documents notification instead of taking up volume 2. Kindly see this compilation. Kindly take up this compilation. Part of the brief. All these documents are part of the brief. I have picked up those relevant documents for your lordship and assistance. Proximate state will come. Proximate state
For your lordship starts. Let him show from the tender document itself where the OPWD applicability is there.
What I know, so
That is not there.
The madness.
And the prayer is sought for seeking passing of a document which is a fraud document. That document is a fraud document. That is the main thrust of the matter.
This is the problem when the opposite party stands up and interdiction the petitioner.
Obviously, right has been
You must maintain the court's decorum.
Yes.
Right.
Security code does not apply here.
Yes.
He is a pre-planned attitude always to interdict the petitioner and disturb in the process of
Yes.
It was very bad attitude.
No.
I humbly say very bad.
Do you proceed? Proceed. What do you want to rely upon?
Right. Kindly similar, clause 36, appendix 9 of OPWD Code, volume 2. This is part of the document. The lordship will find in the paper. Page number 3.
Page number 3. It's an official memorandum dated 31st January.
If the rate quoted by the bidder is less than 15% of the amount put to tender, then such a bid shall be rejected and the tender shall be finalized basing on merits of the rest bidders. But if more than one bid is quoted, decimal up to 2 numbers will be taken for all practical purposes, either at the estimated cost put to tender or less than the estimated cost put to tender. The tender accepting authority will finalize the tender through a transparent lottery system where all bidders, their authorized representatives, the concerned SC executive engineer of the concerned division and DAO will remain present. This amendment to the codal provision shall take effect on the date of issue of the order. Accordingly, relevant existing codal contractual provisions.
Whatever is modified, so they wanted to introduce it.
Right. Now,
this is the provision which they introduced.
Yes. So what I understand from this is, if a bidder, irrespective of any contract, turnkey or the whatever.
Nothing is an estimated cost has been given.
Right. It is open clause. Wherever a tenderer bids a price less than 15%, it is to be removed. Now, kindly see page 6 of my compilation. Kindly see, while considering this tender, what the chief engineer on what basis has considered. Kindly see, this chief engineer pertaining to this particular one. Kindly see note page 6.
Yes.
But last, kindly see.
The price bid cover 2.
Price bid cover 2 of all the qualified bidders were opened on 3/11/25. And the details of the same are as follows. But these are the names of the bidders. I have this private OP number 5 for whom Mr. Manth is appearing at serial number 1. But kindly see the column, 6th column. Percentage excess.
No, I said 18.75 less.
And on the basis of percentage. They are trying to avoid saying that this is not done on the basis of percentage. Now the chief engineer is assessing this on the basis of percentage of less or higher, whatever is quoted. This is I am emphasizing on this.
Correct.
Now your Lordship may kindly see his percentage of quoting less price is 18.75 and mine is 14.99. Now, Lordship may see page 7. All others are also below 14.99,
Yes,
except the last one, excess.
yes, 16.9.
Right. It is found from the statement that L1 bidder VC Bhuya Construction Private Limited superclass contractor has quoted so and so, which is 18.75% less than the amount put to tender. In view of this being a turnkey contract tender, whether to consider L1 bidder with 8.75 less than amount put to tender as per Appendix 9, serial number 36 of OPWD Code Volume 2 may kindly be decided by the tender committee at government level. Comparative statement, other related documents are enclosed herein for
So it
consideration.
was sent, it was sent. Then
It was sent to the government. Now, the tender committee, that I am not privy to the tender committee decision. It's an internal decision of theirs. Tender committee perhaps has decided to approve the 8.75, and that is how I am challenging the decision before your lordship. But tender committee I am not privy. That is why I am not able to challenge tender committee decision. They have also not filed along with the counter. On what basis they have approved it? Whether they have said that this 36 is applicable, not applicable. What is this there in black and white? But that's not before my lords, not before me also. Now kindly see page 8. Okay. Kindly see page 8, man. But this clause 36 was dispensed with by this amendment. Thanks. 3/1/2026. That your lordship will find, after careful observation, government has been pleased to abolish the extant provision of threshold negative bid caps introduced in Appendix
so
9.
that was in a 3rd January.
3rd January 26 that dispensed with.
So
Now,
after the tender is floated and
so grateful, so grateful.
So
Then government has clarified this further also. Kindly see, that is at page 12. Page 12. Clarification on Works Department Office Memorandum dated 3/1/26 regarding amendment of codal and contractual provisions. Lordship straight will come to clause 4, the last clause. As regards the bidding process in which the
it says that it is prospective in nature, not retrospective. Then it's prospective, not retrospective. Whatever has been done earlier will go by
finalized as per clause.
as per the clause 36.
Now-
No difficulty. That's why I say prospective and retrospective.
I am sure.
Your junior has not understood that.
Now, these codal provisions, I am before your lordship with page 16 of my compilation.
Page?
Page 16.
Kindly say what is that document in the reproduction? Sometime more.
No, it is originally as annexure 9, page 930. It is already there.
Kindly read it.
You have given a paper book, we are not shared with that.
He is referring those documents from the voluminous.
It's not given this copy.
No, he has given a copy. Have you given?
No, yes. This copy. you have given.
Yes. So don't be angry always.
No, it is there as it is 930 annexure 9 of the old document.
You would have referred to this.
19 July 2025.
Reproduction, then.
Yes, he is referring. I could see the page number also. Yes.
We got page 930.
Yes, I have seen that. That's why I'm saying.
But this is turnkey basis. Akin to the present tender, I'll show one page to your lordship that my tender is also, this tender is also turnkey. That's the name of the work, turnkey basis. Tender work is hereby cancelled as per work order department 10/7/25. Kindly turn to the next page. 10/7/25. At page 931 of the requisition.
Yes.
I am directed to invite reference to a letter on the subject stated above and to say that government after careful consideration have been decided to cancel the tender and request you to go for fresh tender as the bid amount quoted by L1 bidder is 17.28% less than the estimated cost of the work. That is more than 15% less than the estimated cost put to tender as per clause 36, appendix 9 OPWD code volume 2, which I was just placing. So this earlier page I'm showing.
So
that-
according to you, you wanted to say that there should be a uniformity and the certainty in the decision. In one case, you have applied this clause 36 of Appendix 9
Yes.
and then cancelled it on that ground. Then in this case, how can you say that 36 will not apply?
Both the cases being turnkey.
Correct.
So both the
That is,
cases being.
I understood.
Now, I'll just request my lords to see the tender. Unacceptable.
So what more? What more?
There are two things, this one, your lordship, applicability of OPWD code.
No, that is what something has to be done. You have shown they have taken a shelter. They have taken a shelter in an earlier tender, which is also a turnkey.
Turnkey.
Basically,
There,
they say 36 applies,
yes.
and now you say 36 does not apply. Now he says
Yes.
36 does not apply.
Because it's a lump sum amount. The only word is to say that they are saying that it's a lump sum.
Lump sum. Okay.
Lump sums. That I want to clarify. Well, kindly see on page 32 of my brief.
34 of
Of my brief. Annex 2. Volume 1. Annex 2.
21st April
Right.
document.
Invitation of bid. That is bid document itself.
That's true.
Nature of the work. Yes, but I am just trying to show you, Lordship, that nature of the work, construction of new so-and-so Bhavan, Banijyak or Bhavan Chandraju Bhuvaneswar on turnkey basis in the state of Odisha. So this is also a turnkey tender. That is why I am trying to draw our spine.
So you wanted to draw, but it is not a lump sum, it is really a turnkey basis.
Turnkey basis.
Okay.
Now you cannot pick up the word lump sum, turnkey, something and frustrate my court.
Okay.
Now, Lord, I'll request my lords to further see for 4.4. 4.4. Page 54. The bidder shall write his name. Page 54, Lord, I'm so sorry.
Same volume 1.
Same volume 1.
No, I understand. Because I suddenly got an eye on page 44.
Now, it is page 54.
What about 43?
Page 43.
No. I find whether
Yes, page 43.
13.1.
That's, I was just trying to show you. But my next, I was just trying to kindly similar. The contract shall be whole work described surplus one based on the lump sum bid price submitted by the bidder. So two things are there. Turnkey is there, lump sum is also there in the tender. Now bid price should be the lump sum. Bid price should be lump sum. Then your lordship will see clause 13.2. Bidder shall feel total bid price lump sum price for execution of the work on lump sum / turnkey basis. So we cannot ignore the turnkey aspect. Turnkey is also there. Turnkey basis, including all item of work as specified in the bid documents. Now you will may see applicability of OPWD code. Even if this word lump sum is there, in your tender, you with eyes open, you have yourself applied OPWD code. Kindly see
54.
page 720, volume 3.
You were referring to page 54. I interrupted you. What do you wanted to?
Page 54, I wanted to cite clause 4.2. Percentage is also permissible there, my lord. That's why I was citing page 54, clause 4.4. The bidders are right, kindly see, man. The percentage, putting less percentage is permissible here. The bidder shall write his name in the space provided in the specified location. That's it.
Yes, you have said that the either type the percentage excess or less
Yes.
up to 2 decibels.
Yes. So percentage is not excluded. Percentage has to be there.
Yes, then now you are taking us to 700.
See page 59, man, of the same volume. Lord, your Lordship will get the entire thing here, applicability, blacklisting procedure, all as per OPWD code clause 14.8. Thanks. Chapter 34 of OPWD code volume 2. Accordingly, the officer inviting tenders and recommend to the chief manager state procurement cell Odisha for blocking of quota registration of bidder, and simultaneously actions are also initiated by officer inviting tender for blacklisting as per appendix so of OPWD code volume 2. So I'm just trying to show your Lordship that OPWD
By virtue of a reference, the OPWD code is also applicable.
this statement.
Yes. Then
Now your Lordship has straightway come to 721.
700.
Volume 3.
Oh, it is all one volume. Anyhow, 700.
3. The volume 3 is here.
So it is same thing as 700.
721.
Yes.
Kindly see B-1, the fourth paragraph from the bottom, one line, 1.5 line passage. Bidders
Duties and responsibilities of the engineer.
contract management framework.
No. 721.
720, I'm sorry, 720.
Contract management framework.
Correct. Kindly see the middle line. The bidder shall be termed
Contractor.
contractor for the project in accordance with OPWD code, for which everyone has quoted 14.99.
Yes.
Then kindly similar. The chief engineer Odisha in particular to sanction variation orders, including variation of quantities, additional work which was proposed by the bidder, and all other items requiring specific approval from employer by following procedure as per OPWD code. The chief engineer Odisha shall take approval of the government in accordance with rules of OPWD code wherever necessary. And in terms of this code, chief engineer has calculated and sent it for approval to the government. No? I think. But these are with regard to reference to the clause. Now, so it's the submission that is made that we have cited a false document, that is required to explain. So, volume 3, your Lordship kindly take up.
Page.
Oh, volume 3, your Lordship may kindly take up.
Page.
Page 925. This is a document. We have taken out the percentage from the bid, the comparative chart.
Yes.
And we have prepared this document for your Lordship's assistance. The last percentage part, Lord, we have calculated. Lord, tender ID same, bidder same, work name as per their document, amount quoted as per their document. I have calculated the percentage of it. And for your Lordship's assistance, I have filed it. I owe this document prepared by me for your Lordship's assistance. And this we have taken from the Chief Justice recommendation at the beginning, which I have shown to my Lord.
Chief Justice's
So sorry.
I was shocked that what role the Chief Justice has to play in the contract or a tender.
It's a slip of tongue. I withdraw this. This goes on viral also. I withdraw this. I'm so sorry.
No, this is also corroborated by your document which you relied on in page 6 of the chief engineer.
Yes, sir. I have taken the percentage from that and I have found this consolidated chart.
Yes.
So it can be said to be
So that document is more sacrosanct.
more. So with this manner, I'll humbly submit two things.
So was false document.
They say that this is a false document.
Okay. This document is a false. Okay. So according to you, it is you have done the exercise.
I owe the responsibility to man. Then in the counter manner, kindly see counter F5.
Yes. Where is the counter?
Mr. Sahai is on line program.
I could not reach my Katak, so my learned friend is there. I shall try to be whatever assistance I can.
Who is there?
Mr. Saha is appearing with me. in this.
Oh. Okay, counter is by whom?
By 4.
No, no, counter is by whom?
Counter is by the state.
No, no, opposite party number?
1 to 5.
Opposite party, by the opposite party, 1. They have said 1.
1, okay.
But
No, I've got a 6. Counter of opposite party number 6, that's why I'm asking.
They've got counter filed by OP number 4 on behalf duty being authorized by OP number 1. See, not when we file a
Flag B.
counter, we must
Why it is not given?
slightly similar. When we file a counter,
I know, but why it is not given?
Pagination is.
No, no, in the column, they are not indicating the counter by whom.
And it's ready. No, pagination is not there. That's why that
No, no,
index
B is a vacating application.
no, flag B.
Flag B, it is flag B.
Oh, I have been given flag B. Counter affidavit of by opposite parties. Yes.
the counter is by the opposite parties.
So that I got, opposite parties.
1991
By opposite
2022.
parties.
Opposite parties.
Yes, I got that.
Yes, Lord. I'll just cite one document out of
This is opposite parties.
Internal page
Yes.
22, annexure 8/4, later dated 15/12/25.
Affirm the deponent is a Priyabrata Samantora.
Yes. From Ratikanta Mahapatra to Chief Engineer.
No, no, no.
Acha, deponent, yes. Priyabrata Samanta, right?
Yes. Page.
Lord, the internal page 22, annexure 8/4.
There is no 22 page.
Lord, internal page of the counter.
No,
Annexure 8/4.
no.
Yes, it is.
Lord, this is the document. Can I hand it over?
A by 4,
F for fan.
B by 4, C by 4.
F by 4.
A for
No,
fan.
it is not here.
Page 20.
22.
22.
This
Yes.
ends with C by 4.
Is the F by 4.
This is C by 4,
Hmm.
but thereafter no F by 4. Nothing.
But how?
So this
This is the-
this is F by 4.
Can I hand it over, madam?
1512 to 25.
No, no.
I can take this one.
This one.
On screen also it's there.
No, no. This. Oh, no. E is there. E. What is this? Yes.
This is it.
Anyhow, it is not there.
ତଳୁ ବାହାରି ଯାଇଛି ବୋଲି ତ ଏଇଟା କନଫ୍ୟୁଜନ
No, no. This is D.
This should have come.
This is E.
Since it has come
This is E by 4. And then there is nothing.
This is F by 4. This is 20.
Thereafter.
ଆଉ ସେ ଦିଟା କୁଆଡେ ହଜି ଯାଇଛି ସ୍କାନ କରିଦେଇକି ରଖିଦେଇଛନ୍ତି ସେଟା
Yes, yes.
On my lord's board there.
No, no, I got it.
This document, if you could see,
15, 12, 25.
right, there is a reference, there is a handwritten part, there is a reference that tender committee has approved it. But while referring to this letter in all fairness of things, government should have filed the resolution of the resolution so as to enable us to know what is the basis on which, how could you approve that is.
Simply says approve the lowest quotation. Lowest quotation.
As per the tender committee's decision, but that decision is not seeing the light of the day. Nor it's coming to my lord's board, nor is given to me.
Okay.
How could you dispense with 36? How could you dispense with all our objections where I have raised the issue of discrimination?
Then?
But therefore, to sum up and sum up my whole submission, there are two things. The tender being a turnkey, where the use of the word that lump sum would not absolve you from the turnkey basis as is there in the tender, because every word in the tender notice has to be given due importance. But I'll cite judgments to that bit also. So my submission would be, clause 36 will apply in full force to this tender, whole process. Now, the state government is bound by its own tender conditions, where you have yourself said that turnkey and applicability of OPWD code, you cannot dispense with applicability of that code. Second. Third, you cannot selectively apply OPWD code. In case of another tender, you will say that 36 will apply, which is turnkey, and this tender will not. It amounts to discrimination. And if your lordship agrees with me that 36 is applicable, then there is apparently violation of clause 36, the whole process. The selection as L1 should be. And I am citing Vidarbha and your medical resources, your lordship. Para 16. This is Vidarbha. Para 16. It is clear in It is clear even on reading of this judgment that the words used in the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. Given the fact that in the present case an essential tender condition which has to be strictly complied with was not so complied with, the appellant have no power to condone lack of strict compliance. Any such condonation as has been done in present case would amount to perversity in understanding or appreciation of the terms of the tender conditions, which must be interfered with by the prosecutor. Relying on Vidarbha, you have achieved medical resources, you have achieved will prove. Para 7.3 onwards, you have achieved. I did not read. Your lordship has delivered the judgment on these points. This is Raman with you. Para 7.3 onwards, Vidarbha is letter. That's 7.1. The words used in the tender document cannot be ignored or treated as redundant or superfluous. Metro Rail Corporation, your lordship has been pleased to cite. Then para 16.
Yes.
Right. These are the citations.
No.
That is state government.
Oh, you will not. You are a successful bidder.
Yes.
Yes. Yeah, yes. I will hear you. Let the state give a reply first. On the last occasion, who argues?
Senior.
Okay.
I will first broadly point out the main points of arguments which I am going, and then I will go to the relevant documents. First, in our mind, we have to understand what is the meaning of a lump sum or a turnkey contract. I am using it in simultaneous manner. And what is the meaning of P1 or composite contract matters?
What is composite and?
What is the difference between lump sum and?
No, I understand. Turnkey.
This is a composite or percentage rate contract.
Oh, it's a percent.
It's in turnkey or lump sum contract. Estimated cost of the work is not mentioned. And on the other hand, when the work is a P1 or a composite contract, estimated cost is mentioned. I will show those documents. Second point would be the tender document specifically.
So according to you, this particular tender does not have the estimated cost. Okay.
And the second point of argument would be the tender document specifically mentions that the lowest price will be the responsive, financially responsive money.
Correct.
I'll show that clauses from the tender document.
Yes, that I have page 44.
Yes, my lords, clause 13, my lord.
Yes, we have.
Yes, my lords. Third point would be, my lords, public interest will outweigh the private interest, my lords.
That we have also held in one of the judgments.
My lords, lastly, the notification which my learned senior is relying upon 31st January 2023 is not applicable because it specifically mentions that it is on an estimated cost. Now,
You can just show me from the tender document that any estimated cost is given or not given.
not given, my lords. My lords, if I may refer to page number 20.
I understood. That's I think, the solitary point.
Yes.
One is the solitary point. I think no other point should be gone into.
Page number 26 of the bid document, annexed to my lords.
Yes.
Here, my lords, this is the starting page, which refers to request of proposal, my lords. Here, my lords, I will pause here, my lords. The counter affidavit filed by the private respondent have annexed a document which is a first composite or a P1 contract, my lords, that is annexed A by 6. In that document, my lords, specifically mentioned estimated cost, my lords.
Oh, I understand. Madam, that's the only at your BS.
Yes, my lords.
Because the OPWD code, this clause 36, talks about the percentage on the basis of an estimated cost. If the estimated cost is not there, then the question of percentage will not arise. How that will show us that's the end of the matter.
The
Nothing.
entire bid document does not contain the estimated cost.
That's all.
Yes, my lords.
That's the only thing. Let him answer whether it contains an estimated cost or not. Does not contain an estimated cost. I think that is the only issue.
Percentage will not be. So that
How can you calculate the percentage if the estimated cost is?
that's why he has not taken that.
Correct. That's the only thing.
Yes, my lords.
30 seconds.
Yes, my lord.
You should respond. I think you should take rest.
Right. My lords, I'll just do two.
Just show us.
Yeah.
36 talks about the estimated cost. Whether there is an estimated cost.
Kindly turn to page 990.
What it says.
Paper book, page 919, clause 7. Amount put to tender 215.40 crores lump sum.
No. Estimated cost is different than anything else.
But this is the cost of the tender.
Page?
Page 990.
919.
जितना कागज दोगे उतना ही दिक्कत है.
Kindly see page 919. Amount put to tender.
Yes.
The value of the tender is this.
पूरा ब्रीफ से थ्री भी चल उनका वॉल्यूम दे दीजिए तो ये तक तो दरकार.
Kindly see, before that, page 53, my lords, kindly take the pen of funding to page 53. They have used the word estimated cost. Now they cannot figure out.
Where?
Not page 53. So far as EMD part is concerned, clause 2.1, EMD or bid security payable along with the bid is 1% of the estimated contract value or as mentioned in the bid down. Kindly see that page.
So what is this? The Annexure 7, 919.
919.
Yes, we were referring.
This is clause 7, amount, the value of the tender.
That is annexed.
Kindly see.
No, amount put to tender, I understand.
215.40 crores. Then this is the estimated value. I will take your lordship to page 53.
Page 53 of?
Volume 1. DTC. DTC.
No, it is not. Page 53 is not.
Page 53 clause 2.1. We start from the payment of EMD, bid security and cost of the bid document. It's volume 1, page 52.
1% of the estimated contract value.
Yes.
Where?
Clause 2.1, EMD or bid security payable.
Where? Which clause?
Clause 2.1. Let me read it as a
No, 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 no.
So you are accepting bid security or EMD on the 1% of the estimated contract value.
That means what is the meaning of the estimated contract value?
That is the value they have advertised, my lord. Page 69, my lord,
The contract value
kindly see, my lord, page 69. Kindly see. Same volume, page 69. Was 16.1. They have more clarified it here.
Yes.
Page 69 plus 16.1 bid security. Last quote one. The bidder shall furnish.
Yes.
The bidder shall furnish as part of his bid security for an amount of 2 crore 15 lakhs 40,000 for his particular work.
They have quantified. They
Yes.
can quantify the amount.
So the amount is quantified. That is the bid value. Equal for all. That is the estimated value.
How can it be? If they say that for participating, you'll have to give
So
say
that is-
10 crores rupees as a security. That's all.
Of the estimated value.
No, that is not says 1%. It simply says that the bid value, bid security, quantifying.
Kindly see 2.1 with this 16.1. Your Lordship will gather it, sir. That has to be gathered.
That is what I'm saying, that it is to be considered in this way. If they have quantified whatever, anyhow.
Estimated contract value. Kindly see the language. Estimated contract.
That is what I am thinking of.
Yes.
Estimated cost and estimated contract value.
In that.
Interchangeable according to you.
Yes.
Yes.
They have counselly words like this, but it is interchangeable. There is no.
Is there any correspondences from their end which says the estimated costs? Something anywhere in from their correspondences?
That is in fact page 919 which I have shown to madams. The value bid value. Amount put to tender.
No, that is not a part of the tender document. What's the part of the
Proceedings of technical evaluation committee.
No, that is a different.
For this particular work. This is that technical evaluation committee's approval, administrative approval, amounting to rupees 2 crore 66 lakhs has been accorded by Chief Minister. Then amount put to tender is this. This is the value of the bid. Exact quantified amount.
They have disclosed.
Basing on that, everyone has quoted percentage value within 14.1. Sees this.
What is your explanation? Because this was not placed before us by him. So
My answer to this is, clause 2.1 is qualified by page number 69, which my learned senior showed. That's one more clause I will show in that same page, 69 minutes. 13.2 bid price minutes.
page.
69 minutes.
Yes.
Bid price. The bidder shall fill the total bid price in figures as lump sum price measures. And bid security is specifically mentioned what is the amount measures. 2.15 crores.
Oh.
Specify that what is the EMD or the bid security amount measures. And the reliance on 9191 lots, in my humble submission, is misplaced, my lots. Because this is not part of the technical tender document matter. The technical evaluation committee's proceedings matter. Even my lords.
Yes.
Date number 43, my lords, where bid price is explained.
Where?
Page number 43 minutes.
Oh,
Minutes I will place reliance on clause 12. 12.1 covered. This shall be named financial bid and shall comprise the lump sum bid price. Clause 13 minutes. The contract shall be for the whole work as described in subclause 1.1 based on lump sum price bid submitted by the bidder. The bidder shall pay the total bid price and lump sum price for execution of the work on lump sum or turnkey basis, including all of items of the work as specified in the bid document. The price tender shall except in so far as it is otherwise provided under the contract, include all constructional plant, labor, supervision, materials, so and so, etc. Liabilities obligation set out by the implying the contract. 13.4. The lump sum bid price quoted by the bidder shall be fixed for the duration of the contract and shall not be subjected to adjustment on any account. The second code of argument, in the tender document, what is prescribed is for being financially responsive is the lowest bid. What is prescribed under the tender document, is who will be financially responsible, or L1 is the lowest, whoever has quoted lowest price bid. For that, may I refer to page number 46. Clause number 25.
yes.
Clause number 26.1 E. It is substantially responsible to the requirement of the so and so. During the detailed evaluation, the financial bid of the lowest evaluated bidder, the responsiveness of the bids will be further determined with respect to the remaining conditions. Even 2.26.3 talks about if a financial bid is not responsible, it will be rejected by the employer. Page number 48, award criteria 2.29.1, page number 48. Subject to clause 30, employer will award the contract to the bidder whose bid has been determined to be substantially responsive to the bidding documents, who has offered the lowest evaluated bid price, provided that such bidder has to determine eligibility criteria. 57,
Yes.
11.7
also.
4.4 also.
4.2 also.
4.4 also. Type of percentage. Excess or less.
Has already, my senior has already shown, and just
Yes.
showing wherever the lowest bid price is mentioned, page number 57. Clause 11.7, opening of price bid and
Which
evaluation. Page number 57.
Yes.
Clause 11.7, opening of price bid and evaluation of lowest bidder is subject to satisfaction of other qualification. Page number
What is this?
58, clause 12, clarification also, We also have, here if I read, for examination, evaluation, comparison of bids, the officer inviting the bid may at his own discretion ask the lowest bidder for clarification of his rates, including reduction of it. In the present case, we had asked the successful bidder for reduction of further price,
12.2. 11 speaks of percent.
Yes.
It's 12.2 also, on opening of the price bid, the system shall arrange financial bids in order of their value, that is annexed at page number 20 of my counter affidavit, how according to the price it has been done,
No, there is no dispute to that.
Yes.
You have done it according to the price. Their condition was 36 applies. And if 36 applies, everything goes.
Yes, to that effect, the only judgment, if I may refer to, is may I refer to two judgments,
Physics.
It's para 70. Only to that respect, my lord.
Para?
Tender in para 70, my lord. Tender inviting or the
17.
17, page number 16 of the 30 minutes.
Yes.
The above mentioned statement of law make it amply clear.
Paragraph 17.
It's page number 16, my lord. The pages are at the bottom. Is it?
I think for 17 is not.
17 in this reference.
Four is there, but 17 is something different. Who's actually is number 14?
16. 16 of
This 17 is
quotation.
it's a quotation.
Quotation. That should not have been done.
Okay. Okay. Yes.
Para 17 minutes classifying D members. The above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirements. And if the interpretation is manifestly in consonance with the language of the tender document and subserving the purchase of the tender, the court would prefer to seek restraint. And this is what, my lord, only prime, because, my lord, here, because the tender conditions contain provision that the lowest bidder will be granted the tender, my lord, it has been done accordingly, my lord.
Yes.
And, my lord, para 19 of Jagdish Mandal, my lord, only. Scope of judicial review and those questions, my lord. Here there is no para 19 scope of judicial review and only to show those two questions.
Para 19.
Para 19, my lord, page number 9 of the document. Minutes here, I would place reliance upon public interest, minutes.
No, that is there. Who disputes this very, I think, the very fundamental principles of law. Yes. Anything you want to say? I don't think so. You have any role to play now.
We have no role to play because we have considered one right has been accrued in our favor. But the only thing your lordship kindly see, the cause of action why started for filing the writ petition. The cause of action started, lordship will find from the prayer of the writ petition. Page 90. Issue a writ of certiorari quashing the impugned financial evaluation dated 3/11/25 Annexure 6.
Correct.
That Annexure 6 is interpolated and that is interpolated.
What Annexure 6 is interpolated?
Annexure 6, lordship kindly see, page 925.
He has evaluated
925.
that document.
Your turn is over.
925.
Okay.
Oh, what we clarify also prepared by himself.
While you are caught, then you are saying that this thing has occurred.
So they are the author of the document themselves, according to you.
Yes.
And they wanted quashing of their own documents.
Okay. And if your lordship kindly find the real.
What is the other prayer?
Other thing is that what challenge is made, it amounts to challenging the tender notice itself. While it does not contain the estimated cost, anywhere it is expressly provided and it is a turnkey basis. So it is equally applicable to all. That means nobody knows what is the estimated cost, but a turnkey basis, lump sum basis. That means they have said this type of work you have to do. They have specified in the tender. So that is why such whatever as per their own experience in doing various work, they have given the quoted the price. And this is also as per the tender condition, the who is the lowest one, that is in the economic gain of the government. That is why they have selected. They are found to be that is permissible and that is high. If your lordship kindly see, my lord, if the estimated cost is not there, has he sought for any clarification? If your lordship will find the clause is there, kindly see the tender clause. Page 41. Page 41.
41.
Yes. Clause 9. Clarification of bidding documents.
No, that is what is referred. Oh, no, this is, no, it has not been referred. Yes.
Other clauses I am not referring.
No, I got you.
9.1. A prospective bidder requiring any clarification of the bidding documents may notify the employer in writing or by cable, hereinafter cable, includes so and so at the employer's address indicating in the invitation to bid. The employer will respond to any request for clarification which he received within 15 days. Then Lordship can see 9.2 bid, pre-bid bid. Never raise such a point. Then your Lordship kindly see this is the first prayer aspect, and now your Lordship kindly see the cause of action. But his cause of action started, your Lordship will find that after this opening of the financial bid on 3/11/25, that means according to me, which is sought to be quashed, Annexure 6. Then he has given a letter on 4/11/25. What is the occasion for him to know what is the price quoted?
Because it was opened on 3rd.
Because that is in-house consideration, it is in the bids of the consideration, the final decision is to be taken by the government. So according to their wisdom of knowledge, if they have calculated this, but that estimated cost is
The financial bid must have been opened in presence of the participants. They cannot secretly do it.
That is not.
If they have just opened and then say that these are the prices.
But evaluation will not be done.
Evaluation, he says that I have done it. It is not that you have done it. He has done it.
Can he do this manipulate?
Why not?
Seek for possible.
Why not? If he has taken note of the price, which is quoted by each of the intending bidders, and then if he has a according to him a tender document, if estimated the cost is there, they can immediately take out.
Explain below the repetition to guarantee. He has not stated so.
You can't take an advantage that how can they know? No.
I am submitting his fairness, regarding his fairness. But your Lordship kindly see this document of the tender. My Lord friend from the government side has stated so. What does it say? Request for RFP, construction new Madhukar Bhavan.
The contract and but number 6 declared as L1 bidder. Public commercial biddings access 6. This is
construction. What is this? This is the national competitive bidding. If the national competitive bidding, unlike other tender, Annexure 2, page 26.
Yes.
But what's fine? National competitive bidding. It is unlike other tenders floated by the government. And construction new Banijyakar Bhavan at Chandrasekharpur, Bhubaneswar on Turkey basis in the state of Odisha. Turkey basis is also lump sum basis. And this is unlike the other tender where OPW code specifically is stated to be approved. And that sample document I have given, that is annexure A by 6 of the count. That page is 11. Internal page is 11. OP6, counter of OP number 6.
What for?
The Lordship, I draw your Lordship attention to annexure A by 6, a specimen copy of the tender, wherein specifically OPWD code applicability has been prescribed.
So he's also saying so.
Here it is not prescribed. It is in the process of consideration they will take that.
Oh, that is what.
Yes. So this is the difference. Is there.
Okay.
Lordship, kindly see this.
No, understood. You wanted to say that their reference to earlier tender which was cancelled?
No, that what is record, that tender as a whole was cancelled, and that is a case, whatever the case, that is a different tender process. I am not concerned with that. But that is not a supposing what has been done wrongly, that negative equality cannot be applied. That also they can explain. Because in this case, how can I foresee that something is estimated cost? Accordingly, I will lower down, and also to that extent I will put. It is equal for all. 11 bidders participated. Out of them, 7 were selected in the exam. But here specifically, Lordship, kindly see, this is not a national competitive bidding. In this case, they have specifically stated that OPWD code will be applicable. So here nowhere it is present. So that is why, Lord, what has been done, rightly done. And Lord, all decisions are there also. I have brought Lordship.
What decision? On what principle?
That is in the interest of the public interest and the revenue.
Oh, that is always there. Individual, if it is pitted against an individual interest and the public interest will prevail.
Right. How do we But you kindly see para 6. Para 71 has been.
Oh, this is the reliance has been placed.
Yes.
What is the ultimate decision?
Ultimate decision is
Paragraph 50.
1
No, what is this? This has got no nexus, no connection. No, 15 is no connection. That's a different. That's a case of stopple. Stopple, that once you have participated, you can dribble out.
Beneficial that way, in the lowest rate. And it is according to the tender. Yes.
This.
He has given. That's right. Who has many council?
Thank you. No. Yes. You have done correctly.
The person who was given a switch judgment.
Send the other lead to take it.
Yes, please.
see the 8 period, see the 8 period, but counter.
File rejoinder. Within 1 week.
My lord, evidence, personal appearance of the petitioner, my lord, directed, here, handled by the police of the rally in the Bhubaneswar, could not form order.
Yes.
My lord,
Next day, you 1 week, fix the matter, no? Yes,
my lord, directed for issue from notice, cooperation. The notice has been issued, but nobody has yet.
Whatever, record that. Yes.
Item number 5.
In this case, the petitioner said, he made an allegation that on a government of Orissa scheme to purchase the sports item for 34 Gram Panchayat on Gunagar block file. I got information on the RTI that everything has been purchased from 30 block file. All duplicate sports material has been purchased and handed over to all the Gram Panchayat. On my complaint inquiry, they have undertaken the inquiry by the vigilance. Vigilance is now has become slow. I have some actual information. What has been undertaken, they are not giving any response.
You have to take instruction on this matter, left. He's
2 weeks. To take instruction.
Item number 6.
Please, your lordship.
Again, Gochar land.
The matter is listed before Honorable Single Judge.
Construction of the houses and the water reservoir without the reservation or conversion.
No, what has happened, the enforcement was there, they have the enforcement cases, will see the instruction. And there is another the allegation they are taking that a water tank is being constructed.
Have you removed the defects? You have paid the court fee?
The matter is listed before the Honorable Single Bench, and the Honorable Single Judge has taken a view that this is considering the prayer session of the writ petition. The matter is appears to be a PI matter. So Honorable Single Judge has referred this matter to your.
I am asking simple things that you have said that they are making certain constructions on the Gochar land.
Yes, ma'am.
Without any de-reservation proceeding or a conversion proceeding. So that is what we wanted an answer from him, that whether it has been de-reserved or converted.
And the de-reservation proceeding is going on, and simultaneously a water tank is being built by the government to supply water to the entire village as well as nearby villages.
So it is only a pillar which is constructed, not the whole area which is.
So some encroachments are there. We have indicated encroachment cases, and that process is also going. So very soon they will be evicted also. That numbers also we have given at the bottom.
It is only a overhead tank. There is no house which is constructed by you.
Nothing.
And whoever the encroachers, you have already initiated a proceeding.
My lord,
and this water will cater the need of the villagers.
Not only this village, nearby villages also.
So they will be benefited by the supply of water.
Yes, ma'am.
Brother, there is nothing.
No,
sir. They have initiated. They have started a proceeding against them. Let them do it. What is once they have constructed a tank, it is only on the pillar. That's for the larger benefit of the public.
No, my lord. My submission may kindly be appreciated.
Yes.
Law says that any attempt by either the villagers or others.
Yes.
Law is well settled in the matter of state of Jharkhand versus Pakur Jagaran Manch. Wherein it is held that any attempt by either the villagers or others to encroach upon an illegal or illegally convert the Gochar to house plots or other non-grazing use should be registered and formally dealt with. Any requirement of land for any public purpose
should be made from available waste or unutilized land in the village and not butcher. My lord, it is at 159 page.
Do one thing, file your affidavit, stating that, we'll see to it. Let the affidavit be filed.
I may kindly discuss.
Yes, we do not find, just like, the instant public interest litigation is taken out.
The petitioners are affected by the non-supply of proper road, even electricity.
Non-supply of proper road.
No, there's no road to my plot. There's
Not
no road.
providing the proper road
Yes, and no,
for access.
no street light, there's no drainage.
Why you are not doing it?
The answering opposite part of the municipality. I have made numerous representations.
Who is for the municipality?
I have instruction to appear on behalf of by the municipality. His allegation is there is a road and Google Map shows there are number of roads. And but particular road that he is saying that runs through the railway road. They allege that the railway authorities are not allowing me to go on the road.
That is not.
Which is never a fact.
Annex 6.
And railway authorities are not parties here in this case.
No, I'm not. My
So
grievance.
that comes within the railway's property.
It's clear that it is answered. Paragraph at page 16, paragraph 21, I can't have sir.
I have said that I am bound to use those roads because of non-availability of road.
Page 10 of the Richford song,
Yes,
paragraph 51. It is in the affirmative.
51.
Huh?
51.
Yes.
51, just.
My intent, I'm sorry.
Oh, this is a passage. No, that always belong to the railways.
Railways.
Because they have, yes. It does not belong to them. You can't.
Whereas 6 mile annex.
No, come to page 51. Photograph 4. Fourth photograph.
That is alongside the
Just
railway track.
along the railway track. It is always a railway property because they always have at least the 30 feet or a 50 feet from the track. Always they have.
My intention of putting that photograph is due to non-availability of road, I am bound to use that road. There are other places where road has to be constructed. There are government land, vacant government land.
No, I do not know.
First one is also there.
But this might not be perfect.
Yes, adjacent.
Yes, ma'am. Kindly come to page 17 for a moment, ma'am. Page 17. That is
not clear, but it is the railway track now.
There is no street light, there is no road.
No.
That's also special planning authority. He said special planning authority is a different authority. In his plan, there was
Photograph number
special planning
6
authority is a
also.
party here.
If you see 6,
If you make allegation against the special authority, you cannot make party here.
even 6 is very clear.
I'm not making any allegation, man. I'm just aggrieved by the fact that I
No, sir. Then you have to, railways have to be made a party. You can't do it in this way.
But my intention is because there is no road.
Sir, if the land belongs to the railways, it is a railway who can make a construction. How can the municipality go there? It will be illegal
I
construction.
bow down to that.
So you do it is all side of the railway line.
There is specified places where road has to be constructed.
You'll have to earmark it. You have not earmarked. All those photographs shows it is adjacent to the railway track.
It is there, my lord. Page 17, my lord.
No, sir. Photographs I am looking at it. Where are the roads?
Page 17, my lord. It is.
And what is the ROR which shows a road is there or a path?
It is there, my lord. That's all.
Where the ROR is?
Page 18, my lord.
Yes.
Page 18, my lord. See.
I can't read.
No, it's a photograph. My lord. Page 18.
It is a site plan. Yes.
He property
As per the planning authority,
Huh?
as per the planning
page 19.
let me as per the planning authority, there were specific places where road had to be constructed. They are not.
So where are those? I do not find that. Where is that? How can they make a road on the private land?
The main approach road is page 51.
So that is along the side of the railway track.
The number 1, which is here.
Yes, that is very unclear. We were discussing about it. We are not clear about it. And this is absolutely a road. Why you want a metallic road?
There is no street light, there is no.
The road is there, smooth, one can
because of
drive.
because of no road being there,
No,
I'm being.
there is no, what are you talking? This is not a road.
Well, that is through a railway line, my lord. If I not permit, I'll give a proper photograph to
No, this cannot be done.
I will annex the proper photograph.
No.
Because you have constructed houses.
Yes, there are more than 3,000 residents, ma'am. There are more than 3,000 residents.
Merely because you are facing some kind of inconvenience, that does not mean that they will come and do
I am
it.
paying holding tax for the last 20 years.
So what does it mean?
I have a right for a road to approach.
No, sir. You have a road. You have a means, you wanted a silver road or a golden road or a diamond road to be constructed, you cannot. If your vehicle can fly, there is no difficulty. You can fly, you can walk. First photographs is clear. No, you cannot. Yes, take instructions and come after vacation. It's not a.
I'll also provide some better photography.
Whatever you provide on the next day, we'll consider.
Yes, sir.
Item 8.
Now what has done?
My lord, Utpal University has a statutory obligation to.
Any sector you have spared?
My lord.
Yes. Now this education sector.
Okay. Utpal University, under the usual say, revision of grievances of students regulation 2023 and regulation 6 to appoint an ombudsperson.
Ombudsman.
Ombudsman. It is in the statute that is ombudsperson.
Okay.
And since 2023, no ombudsperson have been.
Yes.
That is
why you are not.
Only university is the party.
So university notice has to go.
Yes, notice has to go.
2 weeks. Or 1 week after.
I will file requisites. I will file requisites for university.
Please.
Item 9.
Requisites.
Yes, sir.
Notice.
And commercial poultry farm. As in
Yeah.
the commercial poultry farm.
Commercial poultry farm. Yes.
This sector, violating the environmental guideline for poultry farms. And from the inquiry report, although it is
What the poultry farm will violate the environment?
Why? They have
These are the natural habitats. They are not using or emitting any smoke or something. What is this?
They are it is the guidelines, environmental guidelines for poultry farm specifies it must be within 500 meters from the residential area. But it has been established within 80 meters, 100 meters.
It should be away 500 meters away from the residential. So you'd say distance now.
Minor.
That is what I'm saying.
Inquiry also has been conducted by the State Pollution Control Board, and it has been revealed that it has been established violating the guidelines, but no action has been taken.
So PIL.
Villagers.
So villagers have come. So PIL. Very interesting concept I have found.
What is
That's a mandamus has to go like a normal writ petition. Even a third party can make an application. There is no difficulty.
Villagers.
So villagers means the public interest litigation. One judgment of the, I do not know. I have already held against.
So how can we know that this has?
You can go for a regular writ petition mandamus, directing the authorities to do a thing or not to do a thing.
Survey capacity is given that the poultry farm having capacity of more than 25,000 numbers of birds are required to obtain consent to establish and consent to operate.
There is a public element required.
Villagers are
Then we are rejecting it that simply villagers are affected. It does not become a public interest litigation.
public also.
It's a word. What is public interest litigation? It does not mean the public oriented litigation. There should be some good cause where the act is silent, something is to be done in a public interest. They are rampantly violating throughout the state, they are not following it. There should be some kind of a mandamus which should be issued. I can understand those. Is a specific personal problem since the villagers are coming, so public interest. Show me the judgment that the moment one claim himself to be the villager, it becomes public interest. Happy.
Villages, if you can see annex for 1 and 2, which villages are living, it is getting ammonia gas, hydrogen sulfide and power. Despite repeated events, it does not address.
What are you doing? Sulfuric, whatever, I do not know what chemical compositions he is using. He is uttering what? It is for the state.
They relied upon a decision, an inquiry report conducted by Orissa Pollution Control Board at page 22. This report says actually the poultry farm was not in operation till the report was signed. He said that they are going to construct it and they have not taken actual measurement. Only he says 80 meters high estimation. 80 meters is not only high estimation. Only says that.
The government is that they are proposing to have large capacity of birds.
Have you started the poultry farm?
My instruction which has senior repair on the opposite party line and to collect the bits and coffee.
Already passed around 15,000. That has already the second phase started. But can you see the conclusion and recommendation? By page 20.
Who is for the pollution control board? You can represent.
Notice.
Issue notice. Pollution. Pause it. Give a copy to him.
Item number 10.
Just have come. What?
The petitioner has filed the present PIL because of the non-implementation of the order passed by the sub-collector in removing the enclosures from the distributed land allotment. The plot is recorded in the name of the electricity department, electricity and irrigation department, and alongside the plot there is a road allotment. The enclosures have been encroaching upon that road for the last 40 years, Your Lordship. And on 6/1/2026, the sub-collector was pleased to pass a common order in annexure 4, Your Lordship, under annexure 4, Your Lordship. And in that comes under the from page number 24. And the sub-collector was pleased to pass the common order that the encroachers have been encroaching upon the land, and the order will be implemented within 2 weeks from the passing of the order, Your Lordship. Since there is, and I am the petitioner, I have been added as a party also in that case, Your Lordship, because I have been fighting. I have given multiple representations. My representations have been acknowledged by the collector, commissioner, sub-collector, and also the ministry, Your Lordship.
Yes, sir. Eviction order has already been passed.
Yes, Your Lordship.
It not been implemented.
No.
Public interest. Seeking an implementation of an order through a public interest litigation. What? Is brother going on? I do not know.
Your Lordship, that is a public road. It has been encroached.
So it becomes a public interest litigation. Yes, why you are not implementing the orders?
Sir, the order was passed and the public announcement was made. We evacuated to evict that area. After listening to those public announcements, some of the encroachers vacated. But then when it's a law and order situation arose, as a result of also discrepancy with regards to demarcation also managed because they protested. So, yes, no.
2 weeks after the session.
Item 11.
Go back, they should even
challenge the application of this evaluation to you. The lines of the construction of the standing are encroaching the public domain.
Oh, yes, yes, not that, why you are constructing a stadium? Well, you have not read it, please consider this act.
I will get
This is a PIL seeking a writ for notifying and implementing the NCPCR's rule for procedures regulating standalone hostels.
Yes, what is this? Yes, you have to. The hostels for the children, if it is there, then we'll have to maintain all the IGs. What is your reaction? Take instruction, come after 2 weeks.
Item 14.
And this PIL and the religious superior mercy to protect the bond, panchayat bond consists of 4.5 acres of land and to the cultural heritage of Shiv temples. My lord, the heavy Tata Power transmission lines consist of 765 kV project is going on from HON'BLE to Paradip, your lordship. So
you do not want that the state should develop, the state should prosper, you do not want.
Villagers wants a little amendment if they are project, your lordship.
What is it?
Then in annex of 3, your lordship.
What?
Simply. So we cannot change the alignment also.
No, we
It is
can't.
the
It is up to them.
Technical persons to decide.
Yes.
This is this ST line is being calculated as per the provisions of following the provisions of Indian Telegraph Act.
Yes, I know.
If they have any dispute, they can approve under section 7D for
Where?
To the authority concerned.
Just let them go to the authority. You go to the authority.
So my lord.
Under the trustee,
My lord, in case of Supreme Court judgment, my lord, it has been observed that the buildings and the rivers and the ponds to be protected and
Sir, that is the inland waterways, that is the act is there, that one cannot convert the pond into any or by filling up of the pond. That is an ecological imbalance. Here it is not a filling. Your own case is that they are taking over the pond. They cannot take it over at the pond. They cannot take over at the road. They cannot take a line over at the temple, everything. So you go before the telegraph, under the Telegraph Act, there is a provision, there is authority, you go there.
Telegraph Act. But in the reportable judgment of Honorable Supreme Court, in Power Grid Corporation versus India Limited versus Century Textile Industry, in Para 24, just I'm reading one line, your lordship.
Yes.
The purpose is to avoid the building's religious space, ponds, etc., while laying down the transmission lines.
Correct.
So here is the case, your lordship.
So that is why you go and raise the objection before the authority under the Telegraph Act. There is already an authority will you not approach the authority? Straight away the court will go. What is there? We do not know the alignment. We do not know what is there. It is the authority who is otherwise competent in this regard. Let them go, approach them. Let them. You have not approached, you should go to the authority under the Telegraph Act. Yes, you go there.
Item 15.
Yes.
Item 15 I'm advised to hire an action of the opposite party 2 to 5 for blacklisting me for regarding future contract mine.
Blacklisting is for the future contract.
And we are signing any future contract.
They will not.
Yes.
Why you have been blacklisted?
In this case, what happened, my lord, a contract, the tender was issued by, I was selected, and in the meantime, on 26/11/2020, sent me a mail to deposit the APS amount within 7. But at that time, I was suffering under malaria, and I was
Malaria?
Malaria.
Okay.
And
What was?
and I have annexed those medical documents.
Yes.
Thereafter, on 13, in the meantime,
What was that?
But in the meantime, the amendment,
Before the last date of submission.
Lordship, last date was 10/1, Lordship. 10/1.
And when this corrigendum has come?
7/1, Lordship.
So before that.
Before that, Lordship.
Yes.
And they said this amendment clause is applicable to this tender.
Correct.
Lordship, kindly see page 82.
Yes.
Then, Lordship, kindly see the next page, Lordship. That is page annexure 8. Technical bid open and my price bid open. I declared L1, Lordship. Lordship bidder. Page 91, Lordship, kindly see. Lowest amount quoted by Lordship, page 91, annexure 8.
Yes.
Lowest amount quoted by Sri Infra Private Limited. That's my amount quoted. They declared me Lordship bidder, Lordship. My name, I believe, serial number 2. I quoted Lordship.
Oh, you are 18 point something. Yes.
He declared Lordship L1, Lordship.
Yes.
Then Lordship kindly state on annexure 9. The people at Lordship, they have come up with the second corrigendum. Just reverse to the government corrigendum. And after Lordship declaring me L1, annexure 9, they are saying you are rejected, Lordship, and the people at page 92.
Page?
92, Lordship. Page 92 to annexure 9.
Yes.
Lordship, kindly see the bottom, Lordship, the only. Since the quoted rate of Mr. Petitioner, special contractor and Sri Prahlad Charan Bhau, special class contractor, is less than 15% of the tender amount, their bid is here is rejected.
Correct.
The both statements can
When I submitted the bid.
Lordship, my bid submitted, Lordship, with the due date, Lordship, that is accepted, and my bid.
Oh, I'm asking you when?
Lordship,
On the last day, 10th or what?
No, 15 January, Lordship. 15 January.
You submitted your bid on 15 January.
Because after corrigendum, they extended the date, Lordship.
Correct. Okay.
I bid, with the due date, Lordship, I submitted my bid.
Okay.
Lordship, the people, they selected me L1, and Lordship, what is the people?
No, but then 36 applies. By this corrigendum?
Corrigendum, Lordship, kindly see the second corrigendum.
The second corrigendum, where is it?
Annexure 6, Lordship.
Where is that?
Page 88, Lordship. This corrigendum is contrary to the law.
Page?
Page 88, Lordship.
88.
88, Lordship, annexure 6.
This is on 9-1.
This is a 9-1, Lordship.
Okay.
The second, previously issued corrigendum data such and such for qualification criteria for technical qualification at point number 2 is modified herewith as per memorandum number 632 data such 9 shall be finalized as per earlier provisions in the appendix clause 36 recorded in volume 2. So already, Lordship, they have come up with corrigendum by implementing.
But whatever the second corrigendum says that the rule 36 will apply.
It cannot be, Lordship.
As it was. So
it cannot be, Lordship.
and you consciously know about it and then you participated on 15th.
Yes, that's why, Lordship, Lordship, can annexure 4. First corrigendum.
No, maybe if they can issue one corrigendum, they can issue multiple corrigendum.
Lordship, kindly.
But it must be prior to the last date of submission of the bill.
Kindly see annexure 3. The entire tender procedure, Lordship, guided under the OPW code. Lordship, kindly see annexure 3. They come up with the office memorandum deleting the provision.
No, I understand. Then again incorporating that provision by the second, why not?
How the official lordship, how the tender can invite?
No, that's totally done.
We try-
If they can delete, they can reintroduce.
Lordship, it is by the works department.
No.
They are guided by under the OPW code. OPW code has been amended. And they said, Lordship, this OPW is applicable to them.
No, OPWD, the modification or the amendment has come since when?
3/1/2026, Lordship.
First,
And this tender was floated when?
Prior to that, Lordship, that is.
That's all, that is what it says.
That's why they have come with corrigendum. Annex 1, Lordship, can you see? Corrigendum, Annex 1.
That is erroneous one. Once process is begun,
Lordship.
so the
No.
law as it stands on the date of floating,
Lordship.
that will apply.
But Lordship, here they come up with corrigendum. Annex of corrigendum 1, Lordship, can you see?
Sir, I understand, sir.
Lordship, kindly see, press it.
Sir, I understand. That they say that so far as this 36 is concerned, that will not apply. In the original, the tender,
Lordship.
they said 36 will apply.
Lordship.
Then a corrigendum came before the last date. They say no, 36 will not apply.
Lordship.
They extended. Then they again came with the second corrigendum, said no, that was wrong. 36 will apply.
Lordship, considering those, Lordship, considering those corrigendums, the tender committee open name finance it. Had it been case that Lordship, and this person is stranger to tender committee.
Can a mistake confer any right into a person? I'm just asking.
Lordship, Lordship,
If they have committed a mistake and later on they rectified the mistake.
They have not rectified, Lordship. Lordship, can say Annex 9. It is by another authority. It is not by the tender committee or tender authority, Lordship.
What?
Annex 9 by the engineer in chief. Connected to the tender affairs, Lordship.
So he has said that you can't. You have quoted more.
So, no, Lordship. So that is the condition, Lordship. Lordship, kindly please come to Lordship Annex 8. Annex 8, considering the corrigendum.
It was an estimated cost was given in the
Yeah. Lordship,
If I may just clarify two things, my lords. In the midst of the tender, my lords, first office memorandum came on 3/1/2026, wherein this clause 36 was not applicable. Accordingly, a corrigendum was issued. Thereafter, clarification
9 January thereafter.
on my lords 7.
7 January, huh?
Thereafter, clarification was issued on 9/1/2026 by way of office memorandum, which is at page number 84, my lords, where it specifically says as regards the bidding process in which the tender has been floated before the issue of the work department so and so, the bid shall be finalized as per the earlier provision of appendix. Accordingly, this second corrigendum came into effect, my lords, and the bid was submitted on 15th January, my lords. And now we are in, my lords, and lottery process has already been commenced, my lords.
Lordship, kindly come to Annex 3 for moving, Lordship, page 70. Then Lordship, kindly what? How they have Lordship misinterpret the entire conditions, Lordship, kindly see. Lordship, kindly Annex 3 for movement, Lordship. And the entire tender process guided under the OPW code, Lordship. And till before finalization, Lordship, the amended OPW code amended, Lordship. And they deleted the 14.99 clause, which was the...
Where is that the amendment that has brought 36 gone?
Lordship, that is Annex 3, Lordship.
Annex 3.
Page 78.
And the clarification.
And where it says that the pending one will not be affected by that. Page.
Annex 3, Lordship.
No, it's a 3 page.
Clarification,
78.
page number 8.
78.
Annex 3 that has put the
This is on third.
So after floating of tender.
No, this is where this is that preceding clause.
Close to.
But if affects on the date of the issue of the warning. Prospective. No, there was one clause that the pending one will not be affected or something. No, no, there is another.
That is annex of high leadership. Page 82. Subsequent clarification.
That is why you have made that. Yes, floated. What remains, sir? This was floated in the month of December 2025. Whatever, sir, the language in clause, in the paragraph 4 is very clear.
Lordship.
Mr. Doloi, language is very clear.
That is the lordship.
It never talks about opening or finalization.
No, lordship.
It simply says floating of the tender. Floating of the tender means when it is already published, or floated means that.
No, I am not on that lordship.
So not on that, then what more? No.
Sir, eight lordship. If that is so, lordship, if that is the case, then lordship, what prompted them after 3 months, they opened my financial bid and declared me L1, lordship can come to annex, right?
No, maybe they have committed a mistake. They have committed a mistake, but that does not mean.
If they opened my lordship, they opened my financial bid, it is now known to everybody. Then the department will participate in further tender also, lordship.
No, department.
Definitely, lordship.
Why?
Lordship, my price now is known to everybody, lordship. Lordship, that is the lordship judgment is there, lordship. That is.
No, it will go there.
Lordship, can you press 91 for a moment? They opened the.
Have you gone to a L2? Lottery system is going on.
No, lordship not going on, lordship.
Where is this? Says.
But lordship, can you open the page 91, lordship, for a moment? Lordship, interfere in various matters, lordship.
Yes.
Please come to page 91, lordship.
Yes.
Lordship, 91, that is on lordship, 28th March, 26th March. It is March after 1st January, lordship. 20, after lordship, though the tender is floated since 3 months back, lordship, they opened my financial bid and declared me L1, lordship, by Annex 8. And lordship, kindly see the Annex 9 who has passed this order. He is no way connected to the present tender is concerned. Lordship, how can he pass this order? He is the lordship engineer in chief. Lordship, kindly come to a tender notice who has plotted this tender. This tender by the chief engineer building and bridges works also Bhubaneswar. He is neither in tender committee nor in the tender authority. Can he pass a third lordship? So this order lacks jurisdiction, lacks competency. Because lordship tender invited lordship can come to Annex 1 for a moment. The tender has been floated by the chief engineer buildings and bridges Bhubaneswar. And he is declared me L1. And without any tender committee or restricting any process in accordance with the tender evaluation lordship, this authority has come up with on its own and has disqualified me. That is lordship can say Annex 9 with the authority. He is the engineer in chief. Can he lordship on the matter?
Annex 8. That is 91.
I know.
Page 91. Page 91, this is the engineer in chief.
I understand. This 92 is also the letter.
He declared.
He says that we declared.
Annex 8.
You opened my price bid lordship. Now it is known to everybody.
Name.
No, never invite him authority such and such. Two different authorities, tender calling invite. When a tender was invited by another authority, now
91, you see 91.
rejection.
Just below that white table, gray table.
Tendering inviting authority is the chief engineer building and bridges.
White portion, first line.
However, madam, page number 21, which starts with the tender document.
Who is the tendering authority?
Office of Engineering Chief Rural Works is mentioned.
Who is the tendering authority?
It's engineering.
Page 91 ka.
Please, madam, I saw that, madam.
So,
Madam, page number 21, madam.
so what is to be done?
Tender is invited by Engineering Chief Rural.
Then 91.
I will take instruction to the business. This point has not been formulated in the writ petition.
Maybe.
No,
Yeah.
it's 19.
It's 21, madam.
It's 19, that's all.
Page 19, you will find, or 18, you will find, the tendering inviting authority is a chief engineer, bridge and building. What are they talking? Page 17 is the notice inviting.
First line.
No, brother, page 17 also. Notice inviting.
No, she is misconstrued. Page 22. Madam, page 22, first line.
He's an higher authority. Chief engineer is a higher authority.
Page 22 is the sheet. First line is.
I know. Engineer in chief is the higher authority.
No, he is the tender. Yes. Page 22, first line you read.
Yes, madam.
Read it.
Chief Engineer Building and Business Rural Work, madam.
Yes, yes, on behalf of.
On behalf of Governor of Odisha invites.
Invites.
Yes, madam.
So he is the tender inviting authority.
Madam, however, the offices of the engineering chief, madam, I have to see whether this.
But declared, who declared? Who declared? Page 90.
No, however, 92 is engineering chief, madam.
So he is the same person.
Yes, madam.
Same person.
Engineering chief.
What?
Highest authority in the.
His rural works.
Yes,
not buildings. And
rural works, madam, have issued this tender, madam.
22, page 22, who has invited?
Office of Engineering Chief, Rural Works Office. This, it is invited by Chief Engineer Building and Bridges Rural Works.
Who declared?
You can take instruction whether
91, page 91, who declared?
Chief Engineer Building.
Are you going to select or do a lottery now, tomorrow?
It has already been done.
So have you declared anybody? You said that we are in the process of a lottery. Now you say already done.
Lottery is drawn. I've just texted them, my lords. Lottery drawn in the matter. They are saying yes, my lords. And L1 declared yes.
When?
Today only, because when it's today. It is done today. The lottery was supposed to be invited today.
Bring it tomorrow. You give me that when they are giving it tomorrow. What is 50? Let us see 50. What is the grievance?
Mr. Oppo was arguing one matter and this matter was reserved for judgment 7003. And out of take 5 cases, initial 5 cases, one case your lordship passed the order, where improved order was passed in respect of 2 hours.
No, it is reserved for judgment means what? What is reserved for judgment?
Your lordship takes it 7003, WPC 7003.
Where is that?
7003. Tag in this record.
Well, that is a matter, my lord. There is 2 matters.
It is with regard to bid capacity. My bid capacity was rejected
was not
and I was declared.
Yes.
But this matter was not heard along with 7003, my lords.
Yes. 7003 is what?
That is with regard to calculation of bid capacity. My calculation of bid capacity was wrongly done.
We have already decided that.
7003, it's reserved for orders, my lord.
It is reserved for
order.
Yes.
You just give it to me, we will see to it.
The annexation does not appear for 7003.
Give it to me today itself.
The next senior does not appear for 7003.
No. Just give me a 7003 today to me.
Yes.
I do not know for others. One matter.